23 CR 1653 is called Armando Martinez Martinez. Martinez. Okay, mother and dad were Martinez. Yes.
We were requesting a reduction in the bond.
His bond is, you were charged with the first degree felony of murder. And the bond is at $1 million right now, I believe. What state say? Is that what y'all are showing?
That's my understanding, yes.
Go ahead.
We'd ask that it be reduced down to a reasonable amount.
Go ahead. Give me one. And what the reasonable amount is. And who set this bond? Another, looks like one of the magistrates.
One of the magistrates, I believe it was Judge Collins. We're asking that it be reduced down to $250,000. We believe that is more than sufficient to command his presence. You can put monitors and also daily recording. He does have ties to this community. At the time, though, he was arrested in San Antonio. He was going to a relative's house, is my understanding. He does not have criminal history, though I will represent to the court that there may be a federal hold on him.
For what?
Immigration.
All right. There we go.
But that doesn't.
That's the elephant in the room.
State from.
I mean, is the defendant illegally or legally in the United States?
He's been here for.
That's not the question.
Years, Judge. He has a checking account. He has a.
Is the defendant illegally in the United States?
A driver's license.
Or illegal? What's his status? Do you know? Or you're not going to answer that? Or you read it?
I don't believe that he's legal. He may have had a work permit that has expired.
Well, is there an immigration hold on the man that we know of?
That's my understanding, yes, sir. So the state,
well, until that can get resolved, this court, a bond has served no purpose, right? If the defendant is illegally in the country, there's a federal hold or federal proceeding, and compounded with the fact that he's now charged with murder, a first-degree felony of murder here. This court doesn't feel like a bond is. I mean, I'm not going to change the bond, but the point is why is there a bond at all if he's illegally in this country?
Well, it was set.
I know it was set. Why should it have been set? And maybe they didn't know what the status was, but if he's in this country illegally, and that seems like a bond is not, you're not eligible for a bond. Notwithstanding what's going on at the border, the rules are rules. So the court denies your request. And in fact, I'd like the state to tell me why there's if there should, I mean, he can post a bond and then what? Let's say he goes to bond, he's gone. Could be. I mean, is a bond is he eligible for a bond? The magistrate may not have been in a position to know that and felt like he was eligible for a bond.
Well, on the state side, I believe he's eligible for the bond.
If you're in this country illegally?
Yes, Your Honor.
And there's a federal hold on or something?
That's a different entity, as the court is well aware, and that they go to a different beat of the drum.
Yeah, I know, but if the federal
he's
hold
eligible for a reasonable bond.
Judge, the state is comfortable with the bond staying where it's at.
Okay, it shall be done that way. Your request for a reduction is denied due to the recent court states. Thank you. Jamil Petrie, will you hand me my spinning box?
And so let's go on the record in the matter of Matthew Sneed, 23270.
Good morning, Your Honor. Attorney Thomas Courts appearing on behalf of the defendant.
Thank you. And Mr. Sneed, your name, please.
Matthew Cade.
Okay. And if you, Mr. Sneed, if you had YouTube on or you have this on another device, you have to turn it down because it's
I don't.
what's the word I'm looking for? I can hear myself talking, echoing, yes. All right, so counsel, today's the date scheduled for a probation violation in this matter, and we do have your appearance here. Mr. Sneed is on probation for operating while physically impaired by alcohol, and it's alleged he tested positive for alcohol while on tether on November 13th and failed to for drug testing on November 13th. And counsel?
Your Honor, we would like to plead guilty with an explanation and waive any right to a formal hearing.
All right, sir, please raise your right hand. Do you solemnly swear from the testimony about to give this matter the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, and you heard the allegations, correct, sir?
Yes, Your Honor.
And you also heard the plea that your attorney placed on the record, correct?
Yes, Your Honor.
And as to those allegations, sir, how do you plead?
Guilty.
You've gone over your advice and rights for probation violation purposes with your attorney, correct?
Yes, Your Honor.
And you understand all of those rights?
Yes, Your Honor.
You also understand that by entering into a plea, you'll be waiving some of those rights, specifically your trial and appellate rights.
Yes, Your Honor.
And you also understand the possible penalty as a result of your plea.
Yes, Your Honor.
You understand the recommendation this matters for probation to be revoked, case closed without improvement, 30 days jail, and complete tether.
Yes, Your Honor. I'm actually looking to get that changed if possible.
And you understand that this court could adopt the recommendation in whole, in part, or deviate completely. Do you understand that?
Yes, Your Honor.
And knowing all that, you still want to continue with your plea?
Yes, Your Honor.
Have you promised or anything, threatened you or coerced you in any way for you to enter into a plea?
No, Your Honor.
And counsel, please mark your client.
Thank you, Your Honor. Mr. Sneed, on or about November 13th, 2023, you were aware that you were on probation, correct?
Yes.
And as some of the terms of your probation was to not test positive for alcohol, is that correct?
Yes.
Also, another term was to undergo drug testing, correct?
Yes.
You failed to comply with those, correct?
Yes.
That's all I have, Your Honor.
All right, well, counsel, the condition of your client, it's not for him to not test positive, it's not use any alcohol or drugs that are not prescribed.
Then, Your Honor, and I apologize, just the way the violation was written out, my client is going to tell you in his explanation that he had a haircut and they used alcohol as aftershave. He has 2 witnesses for that. I don't know how the court would look at that as if it's a violation or an explanation.
Okay, wait. Your client is going to tell me that he tested positive for alcohol because there was aftershave used on his face.
Alcohol.
The alcohol, actual alcohol as aftershave. He does have 2 witnesses, if Your Honor wants to hear from him, that have witnessed that at that time range. And the barber was supposed to show up, but he didn't. But he did write a letter. I didn't submit it because I thought it would be hearsay and he would be here, but we can pop that on the screen too, Your Honor. So I wasn't sure, just the way it was written. He technically did violate the by testing positive, but he is gonna let the court know that's his explanation.
You know, I understand that. I just and I'm just clarifying for the record that the condition of probation was not to not test positive. It was not to possess or consume any alcohol or drugs that are not prescribed. So by testing positive, it's a violation. But I just wanted to clarify the condition of probation. You had indicated the condition of probation was to not test positive. I'm stating that the condition of probation is to not consume or possess any alcohol. So I was just clarifying on your voir dire, I was just clarifying the condition.
I understand now, Your Honor. Absolutely. We'll still continue with the guilty plea in the fact of possession due to the haircut.
Okay. All right, and the court will accept your plea as knowing, voluntary, and factually accurate. This is Tocsinville violations 3 and 4. And counsel, is Ms. Haystack somebody that works at the hair place?
Your Honor, unfortunately, the hair cutter is a traveling hair cutter, and he came to Mr. Sneed's home, is my understanding. Both of Mr. Sneed's roommates were present. One of them underwent a haircut themselves, and they're prepared to testify. And the client does have a letter that he can screen share from the barber.
And so is Ms. Halstead the roommate?
Yes, Your Honor.
Okay. And so,
She's my girlfriend, Your Honor.
okay. So, sir, when did you get your haircut?
November 13th. My appointment was 8:30.
October.
Okay. And
I was kind of confused when you said no use of alcohol. I thought that was just consuming it. I didn't know until after I found out about the violation that I couldn't use any product of alcohol.
And I do have an explanation for the other violation too, Your Honor, but I'm just taking one at a time to let the court know.
okay. Well, let me just say this. Well, I'm just going to tell you this, sir. I don't believe this excuse at all. And let me just tell you why. Okay. Your testimony is that you had a haircut at 8:30 a.m.
PM. 8:30 p.m.
8:30 in the morning? Didn't you say 8:30 in the morning?
No, I said PM.
Oh. Okay. And so this event continued per the tether. Oh, either way, whether it's AM or PM, I still don't believe you. 9:24 p.m. is when the event began, and then it continued until 3:02 a.m. That tells me, sir, that it was continuous use. But in any event, what type of haircut do you usually get?
I get faded all the way around the side and then a line up on my beard. And he uses straight razor all the way around, so he uses alcohol all the way around my head.
And for what it's worth, Your Honor, I just want to let the court know too, my client worked that night at 3:30 a.m. and he is prepared to screen share his login credentials.
When you say he used alcohol all around your head, what does that even mean?
Because when you use a straight razor, it causes razor bumps and infections. So the alcohol helps prevent the razor bumps and infections. Most barbers use it.
And how often do you get your haircut, sir?
Once every other week.
You get your haircut twice a week? I mean, twice a month?
Yes.
And you've been on probation since April 27th?
Mm-hmm.
Yes?
Yes.
And this is the first time that you tested positive from your haircut?
Yes. Because this is the first time I got a haircut off of a tether. I now know I can't use it, so when I get haircuts, I tell them to keep the alcohol out.
But then you'll get razor bumps, right? And sir, where is the aftershave placed?
Around my beard. The alcohol goes around my beard, all the way up where he lines it up here, and then all the way around the face to help prevent razor bumps from the straight edge.
Okay. So you're not going to test positive on your alcohol tether at a 0.05 continuously through 3:02 a.m. with that excuse?
I'm telling you, that's what it was, though. I have two people here to testify for me. that was here with the haircut.
Okay, sir, even if you had the alcohol applied after your haircut, so you didn't get razor burn, what I'm telling you is that I don't believe that you didn't drink alcohol.
Where would I have had time to drink alcohol if I had to work 3 a.m. that next morning? I still got to get some sleep. Your Honor.
Right, so one would question why you had a haircut scheduled at 8:30 at night if you
It's
had
his
to
only
work at 3:30 in
opening.
the
I
morning.
did normally I get it earlier, but his only opening was 8:30. So I said I'll take it.
Counsel, anything else?
Yes, Your Honor, if I could just move on to the next violation.
Yes.
Thank you very much. Per the client report, I don't have independent knowledge of this because I haven't represented him for the entire case, but he reports to me that he's never failed a drug test with you. After a violation that I didn't represent him for, he was ordered to get this tether, is my understanding. Upon doing so, he was confused that he thought now that he has a tether, he didn't have to go test. So he admits he violated it, but it wasn't in some nefarious plot. He just apologizes. He thought the tether would now replace the testing, and that explains why he missed that drug test.
Then once I got off the tether, I'd start testing again. I've never had a tether before.
All right, counsel, let me clarify a couple things. Number one, this is not your client's first violation. He had a violation with this court because he consumed alcohol on August 13th, and that was indicated in a police report in the matter that he had had police contact with. And then also his test taken on September 19th indicates the use of alcohol. So those are technical violations 1 and 2. And so the court held a probation violation hearing on November 6th. At which point the court continued your client's probation, extended it 3 months, 5 days jail, you had to report November 6th, and then 30 days on the alcohol tether upon release and outpatient treatment. Mandatory additional jail for any future violation. So that was just earlier this month. And then 1 week later, your client is testing positive for alcohol while on the tether and failed to submit for drug testing. And if somebody has confusion, what would you do, Mr. Sneed? Perhaps email into your probation officer?
Yeah, I actually called her and she didn't answer. So I was going to wait to call her the next day. Maybe she was out of office, but by that time it was already too late.
Sir, there's other individuals that are here at the court. So if you have a question that's urgent, you can contact anybody in the probation department or anybody in the courthouse. There's email, there's all of that. How did you know it was too late that day?
Because I called about 6:30. I think it was like 6:37, 7:30. I called now and she just didn't answer. So I'll call her tomorrow in the morning.
So what caused you to give her a call?
Because I was going to ask her about, do I keep testing? She didn't answer, so I waited till the next day, and I was going to call her then, but it was too late.
What was too late?
I already violated it. I already caught the violation.
How did you know you violated, sir?
I got the papers from Shimke a week later.
Okay, but you're talking about the day of. So you're saying that you were going to call her on November 13th.
I did call her.
And she wasn't in.
Yeah, and she didn't answer.
Okay. Did you leave a voicemail?
No.
Did you send her an email?
No.
And then you called her the next day on the 14th?
No, I did not.
So, sir, what prompted you to call Ms. Shaw on November 13th?
To ask about my testing. And Heather told me to make sure.
So at any point on the 13th, did you call to see if your color was called?
Yes. I did do that. That's what prompted me to call Natalie. When she didn't answer, I said, I don't know if I test or not. So I was just going to call her Tuesday. But that never happened. Then come that like Saturday night, Shimke sent me my violation papers.
So why didn't you call her on the 14th?
I have no clue. Even if I did, it was too late already. I didn't test.
Sir, you could have still been ordered to test that day,
I didn't know that.
but you didn't, well, no, because you didn't call back in. You didn't leave a voicemail, you didn't send an email, but you want me to believe that you called.
I can show you my call log.
And what time is it you called? Check on your call log.
It was actually the 19th at 6:48 p.m.
Okay, so you didn't call on the 13th.
Yeah, it was actually the 19th, 6:48 p.m. I did call her and she didn't answer.
Well, right, that's a Friday night at 6:19 p.m. Okay, so you didn't call her on the 13th, as you just testified to.
I think I called her after I got my violation papers. So I'm telling you, I was not drinking Monday. I stopped drinking
As of when?
as of my first 2 violations, which I already served my time for. In my 5 days in jail, I did a lot of thinking and recontemplating in my life. So when I got out of jail, I cut all my friends off. I don't talk to any of them. I don't drink no more. I go to work and I come home and play my game every single day. And I stream it.
Okay, but sir, you know that your barber uses alcohol.
Yes.
So at any point during the time on probation, did you, because I know that you get the instructions about using products with alcohol, right? You're not using any mouthwash that contains alcohol. There's all sorts of instructions that you receive.
I received that after I got my tether. The whole time on probation, I just thought there was no consumption of alcohol.
Okay, so you got that information regarding your tether, correct?
Yes.
All right, and that would have been on what, the 12th? When did you get out with your tether?
Friday the 10th.
Friday the 10th. So you had all that information prior to your haircut.
They just told me no use of alcohol. That's all they told me.
Right, and you know that that your barber uses alcohol on your haircut.
Yeah, but I didn't think that type of alcohol. When I hear no use of alcohol, I think the consumption of alcohol. As I think any
No
person
use.
would.
No use, no hygiene products, nothing, sir.
Yeah, but when the normal person hears no use of alcohol, they don't instantly think of products with alcohol in it. They think of no use of alcohol consumption-wise.
Then, sir, if you were unsure, you should have asked. Because my order said 30 days jail for any violation.
That's without my explanation. That's just looking at it as a violation standpoint.
I'm sorry, what?
I said, that's 30 days in jail, looking at it from like a violation standpoint without explanation. I'm hoping with my explanation, I can get something different. Because I'm really not drinking no more. I'm actually trying to clean my life up. I just got a house. I got a job offer out in Texas. I'm waiting to get off probation to go to Texas for.
Well, sir, where is this job in Texas? What type of job is it?
We're contracted through Kroger. This is my company. And we unload Kroger's trucks and we store them in our distribution centers. And then when they order it, we ship it out to all the stores.
Okay, sir, if you have a job offer, then you should certainly talk to them about that with your probation officer.
I can if that's a possibility.
Communication is very important, sir. Don't just assume things because that's really not leading you in the right direction.
Yeah, and that's my biggest problem. Even at work, me being the site manager, they tell me my communication skills suck. So it is something that I have to work on.
Counsel, we're going to adjourn the sentencing portion. to Monday, December 4th, because I'm going to have the testing facility or the lab present regarding this, because I'm likely to send your client to jail. I'm going to give them the benefit of having testimony to support what this result is a result of.
Yes, Your Honor.
And if it also helps, I'm now 2 weeks on the tether without another violation after they clarified no use of any products. After that day, I got that clarification. I went and threw my deodorant, lotion, my mouthwash, all that away.
Okay, I'm glad to hear that, because this would be your every other week for your haircut. So I presume that that's going to be today or tomorrow, correct?
Yes.
Okay, so we'll see how that happens, whether you end up with razor bump or you end up testing positive. So 10 a.m. on December 4th.
Thank you, Your Honor.
Thank you.
Wait,
What's that, sir?
can Heather say something real quick?
She can say it on the 4th.
Okay, thank you.
All right, have a good day.
Have a good holiday.
And we are on the record in the matter of the City of Wyandotte versus Angela DiMaggio, 231363. Oh, that's right, because you're here and then you're back on the. All right, and counsel, you're here, please.
Yes, Your Honor. I'm Gil Boyd, P367 here on behalf of Angela DiMaggio.
All right, and may I have your name, please?
Excuse me.
Okay, and change the date scheduled for the arraignment pretrial in this matter, and counsel asks for the arraignment.
Yes, with respect to the arraignment, going over the charges, we understand, and she's saying used to those charges and we would waive from a reading of those charges.
The formal reading, enter plea of not guilty for purposes of the arraignment and as the pretrial counsel.
Pretrial, Your Honor, you know that there is a companion.
Oh, I'm
case
so
that
sorry.
we've already addressed.
I'm so sorry. There's also,
Yes.
there's a lot of other cases for Ms. DiMaggio, but let's just finish this one first. That's fine.
With respect to, with respect to, you know that there is a companion case of a co-defendant that is assigned to Attorney Shipkey. And to keep these cases together for the separate counsel, which is where I'm at on this matter, we are seeking a similar adjournment as the companion case for purposes of obtaining discovery.
All right, the court will adjourn this pretrial to January 2nd at, is that ready, the other one? Tanja? For Mr. Hill, I believe. Was it Mr. Hill? Yes. What time did I do that? On the 2nd of January?
At 9:30.
9:30, okay. All right. And so, counsel, since I didn't call the other matters, so we'll handle bond on all these matters at the same time, but there's also case number 20402, 184241, and 184242. And so counsel asked to these matters.
Yes, as to the three additional matters with respect to arraignment, I have also reviewed the pending charges on multiple of those cases. She tells me that she understands them, and she was waiving the formal reading of the complaints and those charges and would stand to be.
All right, and then we're adjourning all of these to January 2nd, correct?
Yes, Your Honor.
All right, probably the formal reading on all of these matters, enter a plea of not guilty on all of these matters, which is 2042, 184241 and 184242. And the court will schedule all these matters for pre-trial on January 2nd at 9:30 in the morning. And counsel as to bond on these matters.
With respect to bond, Your Honor, I can only say that my client has expressed a keen interest in getting all these matters resolved once and for all.
Well, ma'am, what's taking you so long to come into court on these matters?
I was in jail and I was on tether for 2 years and I was unable to get the I put in FOIA and, the information's unavailable. She said she doesn't have any of the, actually my FOIA, sorry, paperwork is right here. She has no records seeking prior to May 5th, 2021, and no access to records. Wait, let me see, prior to August 2nd, 2007, and after May 5th, 2021. So I was unable to fight the charges and get the information for it. There's no tickets and there's no records of it at all.
Okay, well, I don't understand all that, man, because
I'm challenging the constitutionality of it.
you're challenging the constitutionality of what, man?
Of the stops.
Okay, and so who did you speak with that said that they didn't have any record of this case?
Your clerk. Here's right here. You want to see it?
I'll take a look at that, yes.
I was on a tether for 2 years. Prior to this, I was on a tether and I wasn't aware that I had a warrant.
Okay, just one moment, man.
Okay.
So this is indicating, this is from November 17th. And this is from the records department for the Wyandotte Police Department, not from the court clerk. Indicates any records you are seeking prior to May 5th, 2021 may not be available or partially available at this time. We are currently experiencing issues with that system and have limited access to it. At this time, we are only able to access records prior to August 2nd, 2007, and after May 5th, 2021. Sorry for the inconvenience. That's dated November 17th of 2023. Okay, great.
Right.
Great. That doesn't tell me why for the last 5 years you've not appeared in court on your 2018 matters, or why for the last 3 years you didn't appear on your 2020 matter. So why haven't you appeared at all?
I don't know. I don't know. I had a tether on for 2 years and I thought that if I had a warrant out for my arrest that they would have picked me up on that.
Ma'am, what matter did you have a warrant out for your arrest on?
Apparently for you guys.
Okay. I'm sorry. What matter were you on tether for?
Something with Lincoln Park for 2 years. I was fighting a case.
So what years was that?
2018 till 2022. And it's been almost 90 days and 2 years on a tether.
That's 4 years. 2018 to 2022, that's 4 years.
Yeah.
You did 4 years on a tether?
No, I did 2 of the years on a tether because the officer. I was trying to explain it to him so he could help me with this.
Okay, but ma'am, I'm not understanding what you're indicating either. The officer, what with the officer?
It's a case that's not out of Wyandotte.
Okay,
I mean, you're confusing me.
ma'am, I'm simply trying to find out why you haven't appeared in this court at any point on your matters from 2018 and 2020 until now. That's what I'm trying to figure out. Because I need to assess bond. I need to ascertain whether or not you're going to be showing back up for court, and you don't have a history of showing up for court. So I'm trying to figure out why you haven't appeared in court.
Well, I guess I was scared.
Okay. Are you currently on probation or parole anywhere?
No.
And so what happened, so you indicated that you were on tether on a case out of Lincoln Park.
Right.
Is that for the matter in e-course? They're all at the same court, that's why I'm asking.
It was for River Rouge.
River Rouge, the matter from 2014? No, that's traffic offense. 2020,
I have a problem with a specific officer that did some really. We can talk about it, okay?
Ma'am, I'm not showing anything from River Rouge on your record. I'm showing 2 matters from e-course.
See what I'm saying?
Well, I'm sorry, let me clarify. There's a matter from River Rouge, but it just shows there was a notice to appear. I don't show what happened as a result of your court date. But I'm showing 2 matters from e-course.
I paid $1,100 in fines. Okay, in Lincoln Park. And I did 90 days in jail. And I was on a tether for 2 years. And I guess I was just scared here, okay? I want to take care of this stuff, okay?
Okay, ma'am, if you're tested right now, what's in your system?
Nothing,
Nothing.
nothing but my doctor, that's it.
And what are you prescribed?
Suboxone.
Anything else?
No,
So I'm gonna have you tested right now. And nothing's going to show in your system other than your Suboxone. Is that what you're telling me?
yes.
Okay. So,
I came here on my own retirement today.
Okay, okay, all right. And I've also seen you coming and going quite a bit along.
My son's at home with my mother-in-law or his grandma that is sick today. I take care of her, home health care.
Okay. Well, I also saw you and Ms. Thomas chatting and then both leaving the courtroom. And so I want to make sure that you are substance free right now. Are you substance free right now?
I have nothing to do with her.
Yeah. I'm going to have you go over to probation and you're going to test right now. Is there going to be anything that's showing up in your system? I'm going to take that as yes. So what is going to show?
No, I refuse.
You refuse what?
That's against my constitutional rights. I am not gonna, no,
You're not going to what, ma'am?
I'm not gonna hold myself. I'm not gonna exercising my constitutional right. I don't have to do that.
You don't have to what?
I don't have to go. You want to throw me in jail, throw me in jail.
If the court orders a condition of bond, ma'am, that you're to test,
Then throw me in jail.
then that's a condition of your
Then
bond.
throw me in jail. Okay, I'm gonna come back and take care of this. It's a stupid driving on a suspension, okay?
Well, and you have your current drug, possession of drug paraphernalia, and then you have a second driving license suspended. How'd you get here today?
I got a ride.
From whom?
My son's father. Mr. Hill gave me a ride.
How are you getting back home?
Mr. Hill, he's waiting for me outside.
Well, the court wants to make sure that you're going to appear in court because you have not appeared in court over the last 5 years. And so as to case number 184241, the court's going to indicate a $2,500 10% bond. The event you post bond, no driving. 184242, the court's going to order $1,500 10% bond based upon your previous failure to appear. As to 20402, the court's going to indicate a $3,500 10% bond based on your prior failure to appear. Event you post bond, no driving.
I can post on.
And on the possession of drug paraphernalia, 231363, based upon your history of failure to appear, the court's going to order a $5,000 10% bond. In the event you post bond, ma'am, you're not to possess, consume any alcohol or drugs unless prescribed, and you'll be subjected to random testing. So in the event you post bond, you are to make sure that you are contacting the court here, the probation department, within 24 hours of your release to get set up with your random testing. All right, and we'll see you back on January 2nd. The court's going to also order, as a condition of bond, GPS tether, no house arrest. In Wayne County Jail. All right, thank you. We're going to be going with the officers. Thank you.
Awesome.
All right, question law, record for a quick moment, then we're going to redo Ms. Thomas. We're going to recall Ms. Thomas. And then take the rest for a quick moment.
Carla Culver, that's you?
Yes.
Right there, please. Thank you. 23 CR 1647 is called Carla Culver, who is present with Ms. Mantalini, your attorney and the state's attorney, and you are Carla Culver.
Yes.
Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes, sir.
In summary, this indictment states that on or about September 29, 2023 in Jefferson County, Texas, you committed the second-degree felony of aggravated assault causing serious bodily injury. And raise your right hand. Do you solemnly swear or affirm all statements that you make during these proceedings will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Lower your hand. Is that, do you understand what you're charged with here?
Yes, sir.
If convicted of this second-degree felony, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes.
An agreement's been reached where you'll be pleading guilty, sentenced to whatever sentence shall not exceed a cap of 7 years. So you are looking at no less than 2 nor more than 7 years confinement in prison. You are looking at up to 7 years in prison, no less than 2 nor more than 7 years confinement in prison, and that can be suspended and you can be placed on probation for up to 10 years.
Okay.
And finally, can I place her on regular probation for this? Because that looks like a deadly weapon was used by so I can't put her on regular
Between the serious
probation.
bodily injury and the
Yeah, deadly weapon, namely a vehicle, was used. So
only deferred.
only deferred is the only option for probation, which you could be placed on deferred or unadjudicated probation for up to 10 years in length. And is that your understanding of the options?
Yes, sir.
So you were looking then at whatever punishment shall not exceed a cap of 7 years in prison. If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this offense charging you with the second-degree felony of aggravated assault? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily, that is on your own free will and because you are guilty?
Yes.
Now, I think we need a pre-sentence report.
Yes, sir.
So what we're going to do is order that. We will return back, cooperate with the probation officer when they come talk to you. We will come back on
Be the first week of January.
in January. She'll figure that out here in a minute.
In January.
Everybody will have a chance to be heard, and then you will have a chance to be heard as well. And then the court will make my decision, and then you will move on with your life from there. Yeah. Did you say something?
Yes, sir. She also is asking the court to consider releasing her in this interim period on a personal recognizance bond. She's not able to post bond, and she does have family here in the courtroom and has a place to be during this time period. And if the judge were to release you on that sort of bond, would you or your family be sure that you get to probation to do the report?
Yes, ma'am.
And the interview that they need to do?
Yes, ma'am.
And back in court
Yes,
on the
ma'am.
date that you're told?
Yes, ma'am.
All right. What's her bond right now? No, you're saying it's too much. What is it?
I would thought you were asking a clerk. Well, how much is your bond?
20,000.
I knew it was low, it seemed low. That's why she's still unable to make a $20,000 bond.
What's the state saying?
Based on the seriousness of the charge, Judge, I would object to a personal recognizance bond.
He's objecting to that.
So,
The state's objecting to it. I'm reading, bond is based upon not only criminal history. I don't know of any criminal history she has. I don't. State may know of it.
She does. She's had a misdemeanor probation so far that I've seen that was revoked, Judge.
Okay, well, the terms and conditions of probation are similar to what bond conditions. If she failed to, if she has a history of failing to follow probation order conditions, then the bond conditions are essentially the same thing. But I'm looking at this probable cause affidavit, and this is and the indictment here, which states that you used a vehicle to crush someone's legs.
My understanding is the victim is still undergoing medical treatment.
And also, although
This serious bodily injury was called by the use of a vehicle, which is a deadly weapon in its very definition, the way the indictment is alleging, because it is a vehicle in its use, the way it was used, is capable of causing serious bodily injury or death. That's the way it's been indicted, serious bodily injury.
yes,
I'm disallowing your request at this time. I find that the bond is kind of low anyway. So that's the way it is. That's what it will be. But we're going to get this set for sentencing hearing here in a few weeks. Okay. That's all we can do. Thank you.
We need to get her thumbprint.
She needs the thumbprint over here. Aaron Hall.
Your Honor, everybody's been in the other holding cell this morning.
Sean
And I just
Simon.
wanted to double check with Mr. Hall, Shan Simon also, as far as I know. He's, I believe doctors found him incompetent, like I know that this morning.
Okay, I don't know that, but you're going to go find out for me.
I don't know, find out what.
All on Aaron Hall and Shan Simon.
Oh, gosh.
Did she trip over the leg? The leg thing?
I didn't see that.
No, Rita.
Sit down. Sit down, please. Thank you, ma'am. Sit down, please. Thank you.
Yeah.
Shan Simon, doctor did already find him incompetent, so we'll do that this morning.
Yeah.
And then Mr. Hall.
Here. Okay, that'll be reset for a hearing. Okay, is that what he wants? Do we need him out for that?
No.
Okay, we'll just, at your request, we'll set it for a hearing on Shan Simon.
Unless you felt it was important for him.
We do need Shan. It's not competent. We can do our own
That's where he got those.
analysis, but at the end of the day, I think the jail, the confining authority is the one who has the final charge on that.
And I think my clarification was just ensuring that any credit that he would have approved under the original murder charge.
It says whatever he is, well,
Correct.
it's whatever he's entitled to receive.
Yes, sir.
And he's been in, that's all we can say.
And I understand.
I can't gift him any time that he hadn't actually served under law.
And while I understand that, my concern was that with the new indictment of the tampering, that's what we were trying to avoid, was him having to do an entire another term on that. That was the basis of the agreement.
The murder is alleged in the indictment.
Yes, sir. Yes, sir. I'm making sure we're clear.
So I think that speaks.
Okay.
That pulls it in.
Yes, sir. That's all I want to verify.
But if it does, and if something happens where it doesn't, then I think it's fixable.
Yes, sir. Perfect.
But now we have these two first amended motions to revoke unadjudicated probation in 19-33415 and 33416. Does the defendant waive formal readings of these? And it actually, he's already entered. Is it true? But let's just seal the deal, as it were, and dot the i's. We'll just go over it quickly.
Yes,
Does he waive formal readings of these? Can we proceed in summary?
yes, Your Honor.
And can we take these up together?
Yes, Your Honor.
In summary, sir, each of these motions, first amended motions to revoke unadjudicated probation, which were filed on January 11th, 21 in 33415 and January 4th of 21 in 33416, allege that you, Joseph Gerard Matthews, on March 23rd, 2020 in this court, were placed on deferred or unadjudicated probation for 10 years for evading detention with a motor vehicle in 33415 and theft in 33416. Both of these, each of these being state jail felonies. Is all of that true and correct?
Is it?
Allegation 1 states back in January of this year, you pleaded true. The allegation 1 in each case, which states that you failed to report to the Jefferson County Probation Office on or about April 8th, 2020. And for the months of May and June of 2020 in violation of your probation order. Are those allegations true? You pleaded true already to those back in January, or are you reaffirming your pleas of true to those now?
Is it?
Also, you pleaded true to allegations 5, 6, 7, and 8 in each case that number 5, you failed to report to the Jefferson County Probation Office on or about December 1st of 2020. 6, you failed to work faithfully at suitable employment and provide verification of such in violation of your probation order. 7, in each case, that you failed to provide verification of performing community service hours as required. And finally, 8, you were at a location other than your residence at approximately 2:46 a.m. on or about November 22nd, 2020 in violation of your probation order. You pleaded true to those earlier, January 17th, 2023, or are you reaffirming pleas of true today? And do you understand that a plea of true, a knowing and voluntary plea of true of 1 or more violations of probation are enough to grant the motions to revoke probation by a preponderance of the evidence or greater? Your probations can now be revoked. You can be found guilty and sentenced to no less than 180 days up to 2 years in the state jail for each case. Knowing that, do you insist on plea?
Are you kidding me?
Oh, my God.
You have got to be kidding me. What is going on today? This is a joke. This is a joke. Today is a joke. He needs an interpreter.
I need an interpreter when I cannot express myself sometimes.
Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Reed, we're gonna start bringing people in. People will learn how to act in a courtroom.
Can you hear it? Can you hear it? Matt? Matt, can you hear it?
No, I know.
Okay.
I have no patience for that. Trust me, out of the day, I'm sitting up here, I'm the one that sees the drink.